Excited Utterance, the Evidence and Proof Podcast, Episode 177, Kay Levine, Opinion Surveys Across the Civil Criminal Divide. Welcome to Excited Utterance. I'm your host, Ed Cheng from Vanderbilt Law School. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence. We bring virtual workshops to you throughout the academic year. This week, our guest is Kay Levine. Kay is the Richard H. Clark Professor of Law at Emory University, where she teaches and does research in the areas of criminal law and criminal procedure. Our podcast today features Kay's new article, The Empirical Double Standard: Opinion Surveys Across the Civil Criminal Divide. It was co-authored with Bernard Chow and was published last year in the Iowa Law Review. In it, Kay and Bernard explore the admissibility of survey evidence, specifically surveys of community opinion. As you might imagine, social scientific surveys on community attitudes or behavior can be very useful for informing a variety of legal questions. The most obvious example is probably in trademark law, where opinion surveys have long been used to inform questions about consumer confusion. But whenever the law asks questions about community attitudes, expectations, or even reasonableness, you can imagine that having a rigorous study is probably better than having a judge or jury simply guess on the basis of their personal experience or their preferences. The interesting finding, though, is that Kay's article reveals an asymmetry. Courts seem to readily welcome opinion survey evidence in civil cases, but not in criminal ones. Is this a principal distinction, or does it raise the specter of judicial bias, perhaps against criminal defendants? My conversation with Kay explores opinion survey evidence, its uses, its admissibility, and this striking asymmetry. Kay, delighted to have you on Excited Utterance. Welcome.
Thanks for having me.
Your article, of course, is about opinion survey evidence. To get us started, can you just tell us about what you mean by opinion survey evidence and maybe some of the contexts where we often see it in the legal system?
Yeah, absolutely. So there are certain kinds of doctrinal questions in the legal system that call for community input, where the doctrine that has been crafted by a legislature or by the courts says we're going to judge liability or we're going to judge damages according to what is standard in a community or according to evolving notions of community standards. So opinion survey evidence or opinion polls are a tool by which courts can judge what the community or the society actually thinks on these kinds of topics. It's a way to establish what the community standard might actually be. So, opinion surveys and opinion polls are conducted by experts in the field. Sometimes those are people who work for polling organizations, sometimes they are sociologists or other academics who work in a field, sometimes economists who work in a field. And their objective is to take a sample of people in the relevant community, like consumers of a particular product or people who live in a town or state or nation, in order to get their insight on the particular issue that's at stake. So whether it's, is there a consumer confusion? They're trying to gauge consumer confusion between product X and product Y. Maybe they're trying to gauge damages in a patent suit to see just how much people value a particular feature of a technological device. And if that feature has been infringed, what's the damage to the company that produced the original device? Or on the criminal side of the docket, questions like obscenity, which is judged according to contemporary community standards, death penalty, which is judged according to evolving notions of decency on a national scale, or in the search context under the Fourth Amendment, which is judged according to whether officers have rummage through a space that is protected by reasonable expectations of privacy. And by there, we mean reasonable, what society is prepared to recognize as reasonable. So in this article, we argue that all of these instances are times when courts should be taking account of opinion polls or opinion survey evidence, but they don't do so consistently. They're much more likely to think that opinion polls and opinion survey evidence are relevant to that consumer confusion question or the patent damage question than they are those criminal questions. And that's the heart of the problem that we decided to investigate.
Great. So let me just back up a little bit. The courts are more receptive to this survey testimony in the civil context versus the criminal context. From an evidentiary perspective, what are the key moves? So, how do courts regulate the admissibility of this kind of evidence? And what are the key concerns that courts might have about it?
So, just like all kinds of evidence, opinion surveys or polling data first have to pass a relevance threshold. And relevance in the law, we mean it makes a fact more or less likely to be true, even if only slightly. It also has to pass what we call the 403 screen, which means probative value is not substantially outweighed by prejudice or likelihood of confusion. And then because polls and surveys are produced by experts, they are going to get introduced in court primarily through expert testimony. So they also have to pass through the expert witness screening, which is governed in the federal rules by Rule 702. So we have different kinds of tests in the state court level or the federal courts to judge the robustness of expert witness testimony. So opinion surveys and opinion polls have to be relevant. We have to make sure that their probative value is not substantially outweighed by prejudice or likelihood that it's going to confuse or mislead the jury. And they have to be produced by experts in conformity with standard scientific techniques.
And more specifically, what would we worry about in the, say, reliability of the 702 context? What are the pitfalls that you tend to see in these kinds of opinion surveys?
So, first, I want to point out that the courts seem to micromanage and find fatal flaws in the surveys that are produced by experts on the criminal side. And they are much more forgiving of those flaws in the surveys that are introduced on the civil side. So, the flaws that we might pay attention to as survey researchers ourselves, but also as people following these trends in the court, we want to know, did the expert take an appropriate representative sample of the universe? Did the expert ask questions that are straightforward and not misleading? Did the expert make sure that there was the opportunity for a survey respondent to answer, I don't know, or not relevant, as opposed to pushing somebody always through to give an opinion? We want to make sure that the analysis stays consistent across the survey, that there isn't kind of free floating analytical techniques that the survey researcher is, either employing or rejecting at different points along the way. So we're looking for compliance with the tools of survey research design, which are quite well known in the social science community. And in some areas of law, so well known that there are books and tutorials and conferences all designed to teach lawyers and judges the best way to use expert testimony in the opinion survey context across various kinds of cases.
So I know that this is not the scope of your article, but your comment about the problems of survey evidence raises this in my mind. As someone who's sort of looked at all of these opinion survey cases, do you think it makes sense that we need to gatekeep this kind of evidence as a general matter? So it seems to me that the problems of opinion surveys are quite understandable to a lay audience. So the sample is not representative, or the questions are confusing. And so it seems like this is one of those areas where cross examination would seem quite sufficient, and that we might not really actually even need gatekeeping at all.
So I happen to agree with you. And again, we find much heavier gatekeeping on the criminal side than on the civil side. On the civil side, judges seem to say things like, as long as the survey is conducted in accordance with standard practices, I'm going to admit it, and I'm going to let the lawyers fight about weight as opposed to admissibility in their arguments to the jury. We find much heavier gatekeeping on the criminal side, so much so that we have some judges who are expressing in their written opinions that they don't think that surveys are ever appropriate to answer the questions that are being brought forward in the obscenity docket. For example, one judge in one jurisdiction in the United States said it makes a mockery of what expert witness evidence is really all about. And in the two other areas that I mentioned, death penalty and Fourth Amendment search cases, in the death penalty, surveys have only ever crossed the threshold of a US Supreme Court opinion once. And that was a case called Atkins versus Virginia, where the court was deciding about the constitutionality of using capital punishment for populations that show significant intellectual deficiencies. And it has never used or recognized the appropriateness of opinion surveys or opinion polls to gauge the constitutionality of capital punishment for any other population before or since. In the Fourth Amendment search area, these cases are not being tested for relevance or for prejudice versus probative value or for expert witness testimony robustness. They're just not getting recognized at all. All of the cases in the Fourth Amendment space, save for one trial court opinion from the Northern District of California, don't even recognize that these surveys that have been produced by very well respected academics even exist. So there's the gatekeeping function by itself already has multiple layers. And the heaviness of the gatekeeping on the criminal side is that puzzle that we decided to tackle.
If I can get into the study in a little bit more detail, can you tell us a little bit about how you found this disparity?
You mean the origin story?
Yeah, so I'm partly interested in the origin story, and then I'm also interested a bit in the method story. Now that you see a trend, then how did you more systematically go about it?
Okay, so I'll start with the origin story first. This article is the product of me. I'm a criminal law and procedure scholar, and Bernard Shao, who is an IP scholar, working together to try to solve this puzzle. But the origin story started with me as a criminal and procedure scholar. I've long been familiar with all of the surveys that have been produced by well-respected academics in the Fourth Amendment space, and just how frustrating it has been for all of us who work in that space that every time the Supreme Court addresses a question of was there a search according to the Fourth Amendment, they don't pay any attention to that at all. And the reason that it's so frustrating is because oftentimes the surveys that are done in robust ways by well-respected academics, they point to some discrepancies, some small, some ginormous, between what the Supreme Court decides is a reasonable expectation of privacy and what regular people declare is a reasonable expectation of privacy. So the surveys that are produced in the Fourth Amendment space, if the federal courts were to pay attention to them, would very likely lead to different doctrinal outcomes when defendants are brought up on charges and claim that officers did something to violate a reasonable expectation of privacy. So in my world, the rejection of these surveys out of hand is a incredibly frustrating but very regular feature of the jurisprudence. I also was aware that Atkins was the only case in the death penalty jurisprudence line that ever talked about opinion polls and surveys, although I hadn't studied that systematically. It was just something I knew. And the standard for judging obscenity, contemporary community standards, I hadn't ever really looked into. I had assumed that surveys and polls were a regular part of that, but had never really looked into it. So it really started with like me just knowing what I knew in my own field. And I happened to come across, I can't even remember why, happened to come across an article written by a scholar in the IP space who was writing about trademark suits, which were brought under the federally are brought under the Lanham Act. And all through this article, she's referencing opinion survey data and how courts are talking about opinion surveys and that there's research on how much impact opinion surveys have in the trademark space. And I basically was like, hold the phone. Wait a minute. We have federal courts that are looking regularly at opinion survey data, so much so that there's enough of these cases for scholars to comment on patterns and impact and so forth. So I wrote to a few of my friends and colleagues who work in the IP space saying, is this for real? Because I was so completely blown away that there could be two such opposite readings of the value of opinion surveys in the same federal courts, right? A federal court in the morning could handle a Fourth Amendment case and say, nope, surveys have no relevance at all. And in the afternoon, handle a trademark case and say, bring on the survey. It's a valuable tool. So one of those colleagues that I asked is somebody from my faculty who had recently left us to lateral to the University of Denver. He's an IP scholar. And I asked him this question point blank, and he said, yes, that is true. And then he had mentioned that he had a now a colleague on the faculty at Denver, who's mainly an IP person, but who had recently written something in to help one of these empirical survey papers in the Fourth Amendment space. And that person was Bernard Shao. So my colleague, who is now Bernard's colleague, said, why don't I put the two of you in touch and see if there's something you can do to the two of you together could do systematically to try to surface more the pattern of what's going on. The person who connected us is Tim Holbrook, who has remained on the Denver faculty. I miss him on a regular basis, but I credit Tim with putting this research team together, me and Bernard. And Bernard brought his particular expertise in the IP space, and he has very strong empirical skills. And we kind of put these two things together, starting with this basic intuition, and then to try to see how much deeper it went. So we decided that we had to do something more systematic than just our own intuitions about how things usually go. And we decided the way to do that was to try to identify multiple points on the civil litigation spectrum and multiple points on the criminal litigation spectrum where we could at least draw some comparison. And the points are not perfect analogs for each other, but we identified on the civil space, patent, the Lanham Act cases, so that's trademark and false advertising and antitrust, as areas where courts regularly show openness to opinion surveys. And then on the criminal side, the ones I already mentioned, death penalty, Fourth Amendment search cases, and obscenity as instances where courts show skepticism at best, and at worst, to complete hostility to taking opinion survey evidence.
The $64,000 question, I think, is why the disparity between the criminal and civil cases. And you note this in your article, and I've frequently talked about this on this podcast, but the uncharitable explanation is usually something along the lines of hostility against criminal defendants or some kind of favoritism toward corporate civil defendants. And basically, the theory goes you ratchet up the expert evidence rules in the civil context because it helps the corporate defendants, and then you release any stringency in the criminal context because it tends to help the prosecution. You and Bernard, though, don't think that's the likely explanation in this case. Why not?
So we start by teeing up and then knocking down a series of things that people might have thought provided a legitimate explanation for why this disparity exists. So somebody might say like, well, it's got to be the doctrine, right? Maybe that the civil doctrines call for community input in a clearer way than on the criminal side. Well, that's just simply not true. The call for community input on the criminal side is actually more clear than what we see on the civil side. We considered whether it's a burden of proof, because in a civil case, we're judging liability on the basis of preponderance of the evidence. And criminal, we judge liability on the basis of beyond a reasonable doubt, right? So somebody could say, well, it's survey evidence. Like how convincing could a survey ever really be if you have to prove beyond a reasonable doubt? But we knock that down too, because it's true that on the civil side, these liability doctrines are being judged by preponderance, but surveys are not only being introduced for liability reasons on the civil side. Sometimes it's for damages. And on the criminal side, whether it's the constitutionality of capital punishment or the Fourth Amendment search context, that's not a criminal liability type question. Those questions are not being addressed by courts on the basis of proof beyond a reasonable doubt. Fourth Amendment, it's a pretrial motion that is judged on the basis of preponderance of the evidence. So the only time beyond a reasonable doubt comes in is in the obscenity cases. And even then, all of these questions are pure evidentiary questions. They're being judged first and foremost on the grounds of relevance, which is the same or should be the same across the civil criminal divide, right? If relevance is a 10% certainty, it should be a 10% certainty on the criminal side as well as on the civil side. We take a look at whether the setting and stakes are different in the civil and criminal cases. So we sometimes talk about adjudicative facts versus legislative facts. So adjudicative facts is a nicer description of what happens in the civil litigation context, right? It's two parties litigating against each other, and whatever the court rules with respect to a piece of evidence, the effect of that ruling is limited just to this particular litigation that's before the court. On the criminal side, a court deciding whether surveys can and should shape our considerations of the appropriateness of capital punishment or of police search techniques could have much greater ripple effects. So those are more like legislative facts. Courts are engaging in something that's like much bigger than just the dispute between the two parties. So maybe that's the reason, like they're being very comfortable admitting surveys in the small context, the adjudicative fact thing, and they're like really hesitant about doing it in the big space. That's the legislative fact. So that might be it. The problem with that explanation, though, is what we get to then is so if they're not using surveys, which are hard evidence, in helping them figure out these legislative fact type cases, the ones that have really big effects, what are they using if they're not actually using hard evidence? And this is where we come to our conclusion that they are resting on a sense of moral intuition in the criminal cases, and they don't rest on moral intuition in the civil cases.
Let me go back to the legislative adjudicative fact piece before you go on to your thesis. It actually struck me that that explanation actually cuts exactly in the opposite way. In the civil cases, the survey opinion evidence is going toward an adjudicative fact, and that adjudicative fact is going to be determined by a jury. And so you would expect judges to actually be more careful about the expert opinions that are offered in those cases because you're trying to govern and gatekeep the evidence that goes before the jury. When you're talking about legislative facts, judges can just use that evidence for what it's worth. And so there's no reason to formally exclude the evidence. So I actually think that you're right on that ground. Let me turn back to the moral intuition piece. Tell us a little bit about that thesis, and then I have a question about the idea of moral intuition as well.
Sure. All right. So I'm going to break those two things down. I'm going to talk about the intuition piece first. So, and we're going to contrast judges' reliance on intuition with their reliance on evidence, right? Things that the parties bring to them that have been produced outside that courtroom, that exist outside the judge's own mind, that can be subject to testing and transparency and claims about objectivity. Intuition, by contrast, is something that exists only inside the judge's own mind, is based on the judge's personal history, personal biases, set of personal knowledge or wisdom, the judge's perception of himself or herself as a legal philosopher, as Justice Scalia once said, as a disciple of Blackstone. And under that cover of intuition, all kinds of problematic tropes might lurk. Biases against a person based on gender or race or socioeconomic status, for example. But even without those kinds of biases, the intuition is just like the judge's like system one thinking, this sort of quick reflexive idea like, well, I just know. It's captured in Justice Potter Stewart's comment about obscenity. I know it when I see it. Well, what does that mean? Like it has to be based on his intuition that something is obscene in the absence of any real evidence that could be tested or viewed by another person. So what we argue is that in criminal cases, judges revert to their intuition. Judges feel like the issues at stake in these criminal cases are issues that they can properly deal with using their own intuition. I know it when I see it. And that judges are secondarily unwilling to have their intuitions challenged by the kind of outside evidence that opinion surveys would present. They want to rule on the basis of intuition. They do not want to have their decision making be challenged or checkered in any way by outside evidence produced by social scientific survey data. In civil cases, though, judges don't have intuitions. They are more technical kinds of questions, and judges therefore don't have intuitions and recognize that they need the help to try to help sort through and to help the jury sort through what the right answer should be. So, whether it's an antitrust question or a patent question or even a consumer confusion question, they likely don't have intuitions that drive their intuitive sense of what the right outcome should be. And then we add the moral layer, because I do think in the consumer confusion cases, judges might have intuitions about what would confuse a consumer of bathroom tissue between, the packaging on two products. The judge might have intuition, but it's not steeped in morality in the way that these questions on the criminal docket are. If you keep in mind the standards that I've been talking about over the course of this interview, standards of decency, standards of morality, standards of what's reasonable for a citizen to expect in terms of privacy as against a public law enforcement officer, those things have a very heavy moral component that is just simply lacking in the commercial litigation space. So we have concluded that it seems to us like the most likely explanation for the disparity that we've observed is judges' preference to rely on moral intuition in the criminal cases and to ask for and get help in the civil cases.
I find the thesis certainly plausible, but here's the puzzle for me. If that's true, then why bother creating doctrine that the community views matter in the criminal cases? So why state the doctrine in empirical ways and then open the door to litigants trying to introduce this kind of opinion survey evidence? And part of me wonders, and I wonder what you think about this, whether one might think that it's a smokescreen in some ways. One of my favorite articles is, at least in this space, is Dan Kahan's The Secret Ambition of Deterrence. And there he claims that empirical deterrence arguments are just smokescreens for what are fundamentally ideological battles. Do you think that's what's going on here?
I think that might be more the $64,000 question because all of these doctrines are judge made, right? With the Fourth Amendment space, the court decided in Katz versus United States in the late 1960s that we were going to judge searches by looking to reasonable expectations of privacy. And the evolving standards of decency notion comes from Trop versus Dulles, which is also decades old. And the obscenity line of jurisprudence telling us to pay attention to contemporary community standards also comes from that same period, middle part of the 20th century. There was a case called Roth, and then the Miller test, and then other cases that modified Miller. I don't have a great answer for you. I wish I knew. I think in some ways it might have been the justice of the Supreme Court using language to garner a majority and leaving those terms frustratingly ambiguous for later jurists and scholars to have to work through. But we do know that almost as soon as the ink was dry on all of those opinions, we started seeing betrayals by not just the lower courts, but the Supreme Court of its own standards. So there hasn't been a single Fourth Amendment case where, since they announced that Katz test, where they were willing to rely on social science evidence. In fact, the only Supreme Court justice to even acknowledge that those surveys exist is Justice Gorsuch in his dissent in Carpenter. He doesn't acknowledge it because he's embracing them. He acknowledges it as a way to say, well, legislatures more than courts should be the ones to sort out what society thinks is reasonable. Basically, trying to line up Fourth Amendment with the kinds of objective evidence that the court relies on in death penalty, where the court is much more comfortable relying on statutory trends and other objective indicators by duly elected officials of the community who are the ones the court credits with expressing societal views. It also might be the case, to be fair, that in the 1960s, early 70s, as these doctrines were taking shape with the language of reasonableness or community standards and so on, the social science of opinion surveys was not nearly as developed as it is now. It is right now, the social scientific techniques for conducting surveys in all kinds of areas is quite sophisticated. It may be just that the court, in articulating its standards, it never occurred to the court that people would bring forward actual hard evidence from the community to document these things. I think they maybe always thought there was going to be some role for judicial intuition. And it's only in really recent decades that the sharp contrast between how judges intuit things and how social scientists document things has really come into focus.
Well, Kay, thanks for taking the time to talk about survey opinion evidence and this interesting disparity between its use in criminal and civil cases. Great having you on the show.
Yeah, it's my pleasure. And our hope is that lawyers, especially on the criminal side, will introduce surveys at every opportunity because if the lawyers do not introduce a survey, it's not the court's fault to not rely on a survey. They have to get it from the lawyers. And so we place quite a lot of responsibility on members of the defense bar in particular to introduce surveys at every opportunity, make the courts rule on it, take this issue up on appeal, to start developing a more serious line of argument at the court level for why these surveys ought to be considered.
For me, Kay and Bernard's fascinating paper on opinion survey evidence raises two big issues. One has to do with Daubert itself, and the other has to do with the psychology that is implicit in their thesis. On the Daubert score, it's pretty obvious that Daubert gatekeeping has a deep and troubling consistency problem. Going back at least to the early 2000s, evidence scholars have long complained about a disparity in the way Daubert is applied in civil cases as opposed to criminal ones. The usual complaint is between expert evidence of causation in toxic tort cases and forensic evidence in criminal ones. Evidence of causation seems to get the most exacting scrutiny, whereas forensic evidence seems to get seemingly none. But even in the forensic context, we see inconsistency. Julie Seaman, back in 2013, talked about a tale of two Dauberts. She found, among reported cases, that handwriting evidence was admissible in almost 90% of criminal cases, but only about 40% of the time in civil ones. And even this inconsistency is not particularly consistent. With evidence of fire causation, meaning arson type evidence, her study found remarkable consistency. Arson evidence found its way into court about 75% of the time, regardless of context. Into this space steps Kay and Bernard's fascinating paper on opinion survey evidence. And here, the inconsistency appears to cut in exactly the opposite direction as the usual complaint. Opinion survey evidence in civil cases now gets the free pass, or at least receives considerably less scrutiny, whereas opinion survey evidence in criminal cases gets slammed. Daubert gatekeeping seems profoundly broken. Same kind of evidence, wildly different results depending on context. Some of the disparities can be explained away using various ad hoc apologetics. But can we really say with a straight face now that Daubert is some kind of objective check about methodological reliability? Seems to me that there's a lot of other baggage that's being brought into the gatekeeping analysis. My second thought relates to Kay's thesis that opinion survey evidence fares poorly in the criminal context because those cases all involve issues where judges have moral intuitions. Here, I think the psychological phenomenon known as consensus bias, sometimes called the false consensus effect, has something to teach us. This is the cognitive bias that causes us to overestimate the extent to which other people share our beliefs. So, why is survey opinion evidence disfavored when a legal issue involves moral intuitions? Well, perhaps because judges don't want to hear it, meaning that they'd prefer to impose their own preferences. But also because, in all likelihood, I suspect that judges think that everyone else agrees with those intuitions. Here, Kay's plea at the end of our session that courts gather actual empirical data of attitudes is surely the right answer. But there's another facet to the false consensus effect, and that is that it offers a possible answer to the question why the doctrine in these morally fraught areas is constructed to involve empirical questions of community attitudes at all. A doctrine that is based on community standards is probably much easier to coalesce around. Everyone likes a community standard because the hope, indeed the biased assumption, is that the community agrees with what you think. If you're trying to gather a majority on the Supreme Court, empirical community standards might therefore be the psychologically easy way to go. Thanks again to Kay and Bernard for a thought-provoking article about survey opinion evidence. It's an article that surely raises more questions than it answers. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program and the Texas A&M University School of Law. The associate producer is Alex Nunn, and the production editor is Anirudh Morella. Additional production assistance is provided by Lizzie Herrera, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Ed Chang, and I hope you'll join us again next time when we take on another new work in the world of evidence and proof.